Okay, we have Mr. Williams, you're, I think, our last witness. And if you would, we don't have a card for you yet, so if you'd fill out one of these white cards and sign it, please, sir, we'd appreciate it, and the bailiff will get that from you. And anybody else you're bringing with you to testify, if any.
Good morning.
Good morning.
The suggestion that I or any prosecutor who works in my office would want to lose a case in court, whether it's a judge trial or a jury trial, is gross and false. I take this job very seriously. I know that you all have relied upon the words and impressions of Laura Cannizzaro, Leon Canizzaro's daughter. And I know that she has made
the trial's transcripts.
The information, her impressions about transcripts, correct. Portions of transcripts, not complete transcripts. And I know that she's made it her life's work to criticize my office, and I understand that. She has a right to do that as a citizen. I criticize her father, Leon Cannizzaro, quite a bit, and I believe that's why some of this is happening. But to suggest that this office isn't serious about public safety, isn't serious about delivering justice, is reprehensible. I personally hand-delivered more life sentences to dangerous offenders, personally. Picked the jury, did the opening statement, cross-examined witnesses, personally delivered life sentences to more men than trials are occurred in certain jurisdictions by all the prosecutors there. I have to wonder if today's hearing and some of the questions and statements have been made have more to do with my race, my party affiliation, or my parish. Because this cannot be about what is happening in jurisdictions in terms of public safety, in terms of reducing crime, suppressing crime, and conviction rates. The Orleans Parish District Attorney's Office has a conviction rate that is higher than 85% right now in homicide cases, higher than it's ever been. This is clearly about something else because we're not looking at public safety stats in all jurisdiction, as Senator Barrow just brought up. We're not looking throughout the state. We've given someone an opportunity to perhaps build some name recognition, run for office in this auspicious body, in this auspicious building. Ms. Cannizzaro stated that the prosecutors use one process for motion hearings to get officers there and use a different process at trial. And that is patently false, nor does it make any sense. We have a system described by Ms. Talia, which has been in place, was in place before I got there, called Court Notify, and we rely on it. When it became clear what was happening in Section I, and let me say this, first and foremost, I agree with D.A. Sims. This should not have happened. 11 other judges at Tulane and Broad would have picked up the phone or got off the bench and told me if a prosecutor was trying to go to trial without witnesses being in court or without evidence being there. They would not have let it happen in their section of court. And I'm surprised that this judge let it happen in this section of court, regardless of the fact that he's only served as a public defender, and most of these cases were being handled by the public defender's office. But since 2022, I want to be very clear, because there seems to be some idea that the office, since her father is no longer there, doesn't care about getting it right and doesn't care about getting convictions. Since 2022, and jury trials have recommenced at criminal court, New Orleans has reduced crime rates and improved public safety more than and faster than any other city in this country. In this country, not the state, in this country. Nationally, New Orleans is being hailed as a turnaround city when it comes to all major categories of violent crime. Many reports are highlighting New Orleans as the leader in crime reduction efforts. But here we are. So, look, I know I'm a Democrat, and I know that's not real popular right now in the state. But I think a lot of people, whether they consider themselves to be a Republican or they consider themselves to be a Democrat, private citizens, they would love to see all of us collaborate and work together to make things better. The same way that I sat with the governor and we figured out a way to get the state police in the city of New Orleans to help further reduce crime after reducing it in 2023, 24, and 25, and it's working. The same way that the AG, I believe she's a Republican, has agreed to handle some of those cases in court, and it's working. The AG is even leaning in the city of New Orleans to try to help get us out of the consent decree, because it's time for us to get out of the consent decree. Reason I'm saying this is R's and D's can get a lot of things done when we work together rather than throwing rocks. But there's been a lot of rocks thrown here today. But since we have this quality time together, there is something that the legislature could do that could completely prevent something like this from ever happening anywhere in the state. And we have helped draft a piece of legislation, and we've sent it up to the LDAA, and it should be on your desk soon, that would stop a judge from being able to unilaterally, on his own, allow and grant a judge trial to a defendant just because they want it. 35 other states require that the prosecution agree and consent to a judge trial so that something like this could not happen ever. Now, I can tell you, I was shocked that it even occurred. Because I said before, every other judge, if something was happening like that, would have called as opposed to moving forward. So the law, I'll make sure you have a copy of the draft. That is a problem that in the state law that needs to be fixed and can be fixed. I stand ready to help get that fixed. But I would ask you, Senator Morris, how many judge trials have occurred in your jurisdiction? And how many of them were guilty and how many of them were not guilty? And I would imagine nobody up there is going to have those answers because nobody's measuring it. And if you measure, if something matters, then you measure it. It's being measured here. Now let's talk case specifics as was brought up. We have a very close working relationship with the NOPD. And I reached out to him when I was made aware of what occurred in Section I when I saw Judge Roche's letter.
We're going to get to this, but when you were made aware was when Raphael Goyeneche called you and let you know you didn't know what was going on in your own office. And so that's what I'm going to start with. In addition, when you made your first opening statement, I understand you're defending yourself, but you started out basically calling this committee racist. That was your first opening salvo. So the race card won't work here. I'm just telling you. Wait just a minute. We brought this to your attention because of the Metropolitan Crime Commission. We didn't go out looking for this. That's how it came to our attention.
There have been misleading tweets from the person who was allowed to present and prepare a PowerPoint who has openly criticized this office with false information.
I didn't hear anything was false. She showed us the actual transcripts of these trials. Now we can get to those details in a minute, but let me just ask you this before others want to ask.
I'm allowed to present.
You are. We interrupted the others when
you promise not to cut me off because it gets close to lunchtime, like what happened last time, Senator.
I am not hungry, so no worries. I'm not hungry, so no worries here. You just go ahead. Go ahead, and we'll wait for questions.
Thank you, Senator. I want to talk case specifics. We have a very strong working relationship with the NOPD. We reached out to leadership. Leadership did an internal report on whether or not these officers were properly notified and subpoenaed to be to court. Leadership sent us reports showing that every single officer was properly notified except for one single instance. Now, Court Notify at times has had issues, and we're working to correct those issues. But let me be very clear here. There is no suggestion that what occurred in Section I was in any way the New Orleans Police Department's fault or any of the officers involved in that case. In those cases, the judge's decision to find these defendants not guilty has little to do with police officers or the evidence that the lawyers attempted to present in court. His mind was made up. And in these cases, he signaled what his opinion was of the case in his pretrial hearings by either drastically reducing the bonds or by finding no probable cause for the arrest made by the police officer while that officer was sitting in court after he testified. By suppressing the evidence that was properly collected by the officer while he's sitting in court after he's testified at that motion hearing, by removing ankle monitors of these defendants and lifting stay-away orders, all over the objection of my prosecutors that this is what occurred in motion hearings. And the officers were present at motion hearings because of the notice they received through Court Notify, the same system that was used when the case came to trial. So what I'm telling you is there is a pattern, and the pattern is this judge signaling to the police who have shown up and provided testimony and evidence was presented that he's saying, I don't think there was even probable cause for you to arrest this person, and I'm going to suppress the evidence that you collected in this particular case.
I've got a question. Is it competent for a DA or an ADA to say the state is ready to proceed to trial and then not put on any evidence?
As I said at the top of my remarks, and maybe you missed it because I had something that maybe was a little charge for you in there, because that's how it feels. It should not have happened. And we have retrained the two lawyers that were in that office. My first assistant, Ned McGowan, who's present with me, has instituted Saturday schools, making sure nothing like this occurs in any other section of court. And you know what should be the biggest glaring red flag here is that this did not occur in any other section of court. None of the other 11 judges was there a situation where a judge was jamming up a young lawyer, telling him or her they couldn't get 20 minutes for an officer to make it through traffic to come to court to testify.
You never answered my question. Was it proper or was it incompetent for an ADA to say the state's ready and waive their opening statement and not put on any evidence? Yes or no? I
think it is improper and it should not have happened, and we have retrained those ADAs to not. They should have. We were training.
Fair enough. You
we were
answered
training
the question.
that from the beginning.
It was inappropriate.
But they messed up.
It was wrong. So you did not know about it, though, until Raphael Goyeneche called you and alerted you.
Senator Morris.
Whereby, is this true or not?
Senator
Is
Morris.
it true or not? Let me ask the question. Is it true or not that you had no idea that this was going on until Mr. Goyeneche called you?
Senator Morris, if I had known this was going on, I would have ran over to court and stopped it from happening.
Why weren't you monitoring what was going on in the courtrooms? There are only 12 courtrooms. You can wander from one to one. Why didn't you know about it?
Senator Morris, you saw the numbers for the jurisdiction. In 2022, we were coming out of the pandemic, we were the murder capital. We have a number of murder cases and rape cases that are and armed robbery cases that are moving forward in the 12 sections of court daily. Today, we're talking about 14 cases in one section of court. And you're suggesting that for some reason, the office doesn't care about these 14 victims, but we care about the other thousands? For what good reason? It doesn't make sense. It doesn't stand to reason.
I think it stands to reason when the state claims that they are ready to proceed to trial and they put on no evidence, don't call a witness, don't ask for a continuance, don't seek a writ,
no, sir,
and don't null pros and recharge.
Let's go through a couple case specifics here. There was a case of Tamika Dozart was brought up, which was the burglary of a subway. The court saw the video of the burglary and still found this person not guilty. The owner was very clear, and I want to be very clear, but you asked, I believe it was Senator Abraham asked the question. We had extensive outreach with the victims and business owners in all of these 14 cases that were described. Ms. Canizero was right about the fact that domestic violence survivors can sometimes be ready to move forward at the time of arrest, but when it comes time to point the finger at trial, they are not willing to participate. We were in touch with them throughout the case. The subway owner in the case versus Tamika Dozart, 553-204, was unwilling to come to court. But let me talk a little bit about the judge's actions pre-trial. When the officer was present in court, the judge found no probable cause over the state's objection. He then allowed 3 consecutive defense continuances, and the defendant did not come to court on multiple occasions. An alias capias was issued. We moved to revoke his bond and have that person put in jail. The judge refused to revoke the bond, released them back into community, and already telegraphed what he was going to do with trial with his no probable cause finding in front of the police that came to court to testify based upon court notified.
Why would you go to trial if you thought you didn't have the evidence to prove the case?
I wouldn't do it. Again, I will tell you, if I knew that the lawyer made that mistake, I would have stopped the mistake from happening. It should not have happened. There's no disputing that. The issue...
The buck doesn't stop with you, though, does it?
The buck only stops with me, which is why...
I'm hearing is that you're saying that your ADA's screwed up, you didn't know about it, and you're saying blaming the judge. That's all I'm hearing. The judge's fault and the ADA's that you didn't know were doing things improperly. But I do need to go to Senator Cloud. She's been waiting patiently.
Yeah. Thank you. And thank you, District Attorney Williams, for being here today. I really appreciate you being here. I can tell you, your statements at the beginning disappoint me because, look, I'm from just south of Alexandria. I'm like from, pretty far from New Orleans. I like to visit New Orleans, but what happens in New Orleans, I get calls on. What happens in New Orleans, I have to vote on remedies for. What happens in New Orleans, I am a vote for appropriations on. Legislation and initiatives that I, as a legislator from Central Louisiana, have taken on as far as monitoring goes and investments in monitoring goes, those stem particularly from New Orleans. So what happens in your city, I think for all of us serving in the legislature, we all have a very close eye on it because there are some very, very terrible, catastrophic stories and some major headlines coming out of that, which has meant we've tried. I think we've been very diligent in partnering, wanting to partner with you, wanting to partner with all the stakeholders in New Orleans to help bring remedy and protect your city. So that's why we're here today. That's why we're here. We're looking at our return on investment. We're looking at the effectiveness of our partnership. We're looking at how justice is being served. That's why we're here today. That's why I drove in from Alexandria. But a question was answered in your statement earlier about your ADAs, and I was going to ask you, are they still under your employment? After reading through the transcripts and seeing basically nothing happened, not even a request for continuance, nothing happened. The case was just acquitted. It was just over. And then the particular case that could be reopened that was mentioned because doesn't fall under jeopardy. Why haven't you reopened that case yourself and prosecuted that even yourself? And then why wouldn't you just release those district attorney ADAs from your employment? And another question I have is, were particular ADAs involved in more than one of these cases? Was there a particular ADA, or was it just separate ADAs all throughout? Or was there one particular or two particular ADAs that were involved in these cases that ended up getting acquitted?
I'll take the questions in reverse order.
Okay.
And let me be clear. I'm not suggesting that the members of this dais are racist. What I'm suggesting is that the impetus for the tweets that have been unfairly lodged at an office that is getting better rates than any other prosecutor's office in the country, I believe that is born from something else, not the members of this dais.
Right, but besides the relationship that you and Ms. Canizaro have, can't you see why there would be just cause for concern by the legislature and by this committee?
Well,
and an inquiry? Surely.
Look, I'm here.
Okay. Well,
every time you all call me, I'm going to come.
Thank you.
I don't care about party affiliation. I don't care about race. I believe that we all have a role to play to make things better in the community. But a question was asked by Senator Miguez of Ms. Canizaro if she thought it was purposeful by me.
Well, let's go back to my questions.
Okay, let me answer that question. So we're talking about two prosecutors who are not very far from being in law school, that were very, very young, that bent to the pressure of the court rather than the rules and trainings they received. And they were pulled out of that section of court. They've been retrained rigorously, and they have been it has the full-scale ramifications of their actions have been explained. But the thing that I didn't finish that I think will answer your question when I was talking to Senator Morris was there was robust victim outreach in all of these cases. And by the time these cases went to trial, the people that called the police, the witnesses that we needed in court, would not testify. They would not come to court, and they would not testify. And so, although I am frustrated with what occurred in these cases, knowing that these witnesses have made it very clear they're not going to come to court on a trial date, and we use a system called PBK, which shows every time that our victim witness team calls a witness, every time our DAs call a witness, and so I can track the outreach to see if it occurred. And I can't in good conscience.
Are you? I'm sorry, just for the sake of time, but are you the case that did not have jeopardy attached? Would you reopen? Would you retry that?
I would reopen the case if we got confirmation from the victim that they would be willing to come to court and testify, so that we would not find ourselves in the same situation.
And are you going to look into that?
We are, and we will continue to do that, but we have to get cooperation from those victims, because otherwise it would be a waste of court resources and our resources to move forward with a case when the victim has said, I am not coming to court. In fact, we have statements from one of the witnesses said, this case is stupid, and I am never going to come. In another situation, the witness said, this is an inconvenience for me to come for this amount of money, and they wouldn't come to court. In the case of Darnell Wallace and Allison Conrad, that was one of the cases that was mentioned. And I think Ms. Canizero said something like someone gave condolences at the end of it based on an unrelated matter. This was the Halloween example that Rafael Goyeneche began to discuss. Let me just tell you a little bit about that case, and I'll be very, very brief. The defendants called 911 because their infant son was unresponsive. EMS arrived on the scene, and the child was pronounced dead. The police were there. EMS was there. At some point, after the body of the young child had been taken away, the police department was assessing the scene, and they grabbed a bag that they thought belonged to EMS. That bag actually belonged to the defendants. Inside of the bag, marijuana was found. The police found out who the bag belonged to. They did their job, and they arrested these two people who just lost a child. And they did a search of the home. And they found an illegal weapon in another room of the home. So those are the charges in this particular case. The officer was notified. The officer did not come to court. The judge, at pretrial hearings, when the officer was in court and did explain what happened, the judge reduced the bond. The judge found no probable cause for the arrest, suppressed the evidence in front of the officers, and removed the ankle monitors, all over these same lawyers' objection. And a judge trial was elected by these defendants on that same day.
Did you seek a writ because of the suppression of the evidence?
We did not seek a writ because of the suppression of the evidence.
So you, in effect, tacitly agreed with the judge's ruling. You didn't fight to make sure that the evidence was not suppressed by seeking a writ if they made an improper decision.
It doesn't mean that all evidence was suppressed in the case. Certain pieces of evidence were suppressed in the case. We lose hearings from time to time in court, and we have to make a strategic decision about whether or not to writ every single time that something is suppressed or there's no probable cause finding. And sometimes that is based upon the severity of the case. Sometimes it's based upon whether or not we think we'll win the writ. I can tell you right now, I don't think the Fourth Circuit was going to side with us in a case in which the defendants lost a child, were the ones that called the police, and the police officers grabbed the bag thinking it belonged to the EMS.
Out of all these 16 cases, with the 13 in which there was no jeopardy attached, have you reviewed each and one of those to determine if a recharge would be appropriate?
We have reviewed them. We have made outreach to the victims, the
So
complainants.
you've looked at each one of them, but thus far you have not made the decision to bring any of them to trial.
Because none of those victims have agreed to come to court and
So
testify.
you've reached out to every single victim.
We reached out to every single victim in all of these cases.
After the purported acquittal, you've reached out to every one of those.
I don't know that we've made contact with every single. Some of them had become non-responsive.
But it's clear that none of them have been retried.
Let me just finish. Some of them have become non-responsive as we were getting closer to that trial date that occurred, and they have never. They've changed numbers, and they have never responded to us after that point. If, in fact, we could find if a witness was willing to testify, we could move forward with these cases, but we're not going to do it until that has been established and that's been done.
Senator, are you done?
No.
Did I answer? Did I miss one?
You've done. You've tried. I think I've asked one question that maybe you didn't address.
What was that?
The ADAs, were there certain ADAs that were involved in more than one or multiple cases.
It was only 2 ADAs who were very young.
In all these particular cases,
in these
it was
cases.
2 specific
Yes.
ADAs, so they were all attached. All these situations we've seen were attached to 2 individuals.
2 individuals who were assigned a Section I, who
Over over a 3-year period of time?
no, this was I think this was over less than a 1-year period.
Less than
Yeah.
okay. And no one from case to case, like in your office when you're reviewing the court documents and the findings, the acquittals, particularly when there are acquittals like this, no one in your office or you yourself, like, the head honcho, didn't notice some kind of anomalies going on with these 2 particular, and then they were continuing to get these cases and have such outcomes. Did no one found that peculiar?
I think, I'm not sure, one of the presenters earlier, I think it might have been ADA Sims, said that there are, in all jurisdictions, certain sections of court where they are more defense-leaning rather than state-leaning. We've got maybe a few more sections that are a little bit more defense-leaning than state-leaning than some of the other parishes.
It seems like even the ADAs would come to you and say this is continuing to happen under these judges. I'm fixing to go before this judge again, with another case.
Well,
and
we put something in place to ask for that outreach. When a lawyer feels like they're being bullied or pressured or getting jammed up, to immediately reach out so that we can step in. Because these were 2 isolated individuals who were very young. There is no excuse. And the reason they're not here today is because it is my fault. I am the DA. Anything that ever goes wrong in the DA's office, regardless of who did it, regardless of whether or not I knew about it beforehand or found about it after, it's my fault. The buck has to stop with me,
right.
And I absolutely embrace that. And I don't believe that they should be. I don't believe that their career should be marred forever because they buckled under the pressure of a man in a robe who had signaled by no probable cause finding, saying the police should not have arrested you with the police officer in court or suppressing the evidence. I didn't want to ruin their career because of that. I wanted to retrain them so it would never happen again, and they would never do it again, and put some systems in place so that we could catch any anomalies sooner. We have a new chief of trials.
And you don't feel, Mr. District Attorney, you don't feel that because it was isolated to 2 ADAs under 1 judge, multiple cases over a certain period of time, that there could have been some coordination and cooperation in those outcomes, because from the outside looking in,
I can see that.
yeah, it looks very concerning. And from the outside looking in, one time, okay, you're young, let's retrain. Second time, okay, we're going to move you to a different section. But again, like at some point, no, I can't trust you to do the work of the people.
So one of the deep dives that we did, I know Ms. Gornecci said that he did not check to see if notice had been made the same way. Ms. Canizero said they chose not to. Notice to the department was made the same way at motion hearings. Officers all showed up, as was made at trials, and the officers didn't show up. But when you look at these cases, the 14 or just the ones that they've mentioned, in each one of those situations, when officers were in court, Judge Roche telegraphed saying, I find no probable cause for this arrest. I am suppressing evidence. He is saying what he wants to do. And at that same setting or soon thereafter, their defense attorney says, we would like a judge trial, because they're reading the man's hand. They're looking at what he wants to do with the case, and then that is when they choose a judge trial, which is why we have crafted legislation that would require the prosecutor, a local prosecutor, to agree to a judge trial. 35 other states would never let this even occur. A judge could not get away with this. Young ADAs couldn't couldn't fall down on the job in this situation if it was a requirement that the local prosecutor had to weigh in as to whether or not a judge trial could be granted. And I hope that that one of you will carry this legislation or at least vote for it when it comes up. 35 of the states have done it, and I think it's smart legislation. I think it is a huge problem in our existing state.
Well, thank you for
Thank you,
answering my
Senator
questions.
Cloud. Senator Miguez.
Thank you, Mr. Chairman. Earlier, you're a little emotionally charged, so I want to give you an opportunity to make sure you set the record straight. The chairman had mentioned that his interpretation of your initial testimony was that two ADAs messed up, or used the word screwed up, and that it was a judge's fault, and you said, no, sir. Is that your answer for the record?
No, I think when I said no, sir, I was referring to when he said, so the buck doesn't stop with you.
Okay,
the buck
so
always stops with me.
Yes, so the two ADAs screwed up, right?
I think they did not do the job as they had been trained to do it.
Okay, that's screwed up. And the judges, I had the impression that you were pointing some of the blame to particular judges that were pressuring your ADAs. Is that your accurate testimony?
I don't think I would say I'm blaming.
It came off that way.
I'm not trying to suggest that I'm blaming the judges. What I'm saying is a judge has a discretion about what they do, how they rule, and I have no control of that. And what I'm saying in these cases, the cases that we're talking about specifically in Section I alone, I'm not referring to any other section of court, this judge telegraphed that his appreciation of the value of our prosecution by finding no probable cause for the arrest and then or reducing the bond dramatically or suppressing portions of evidence while the officers who just provided that testimony in court are listening to it. And on that day, in that room, or shortly thereafter, the defense says, we want a judge trial. And so I'm saying that that is a problem. And the way that I believe that problem can be fixed is not allowing judge trials unless both sides of the V can agree to a judge trial. I think that is a problem in the law.
When you started out your testimony, you might have been there 2 minutes, and you brought the race card up and party, and that's generally the position of typical liberal leftist elected officials, and that's the appearance I think this committee took from that. And I can tell you from my standpoint, the committee's standpoint, I think we're most interested in your political ideology as it relates to implementing criminal justice in the city of New Orleans, the safety of that city, and your job performance. And I recommend in the future you not bring up the race card of your party, because as you said, we're all here to work together, and that sets a bad precedent and up front when we're trying to get to the bottom of these problems here in Louisiana.
I respect that, Senator Miguez. Can I ask you a question?
Sure. Well, you're not supposed to, but you can make a statement.
I'll make a statement. The country and folks from all over, the data that's usually relied upon about whether or not cities are getting safer and whether or not crime is being reduced, much of that data is generated by the FBI, Federal Bureau of Investigation, not some local prosecutor. All of the metrics, no matter how you look at it, everyone says that the city of New Orleans is reducing crime at a peak that's better than anywhere else. And then when you look at the data of our conviction rates for murder, rape, and armed robbery, it's higher than it's ever been. And so when the country is taking notice about New Orleans being a national leader in reducing crime and making our cities safer and doing it in a way that is collaborative and doing it faster than any other place, you know, it's just interesting that on the heels of that type of success, that because of tweets and because of information that's pushed out, some of it incorrect, some of it correct, that there would be a suggestion that this prosecutor's office wanted to lose. And that's what she said. And that's what she said. And so I had to raise the issue. It seems odd that a parish that was delivering Now, granted, I know there's a lot of things falling down in New Orleans. We got a sheriff who's got some serious issues, and I appreciate the AG leaning in at a time when she's fallen down. And we got a host of other issues. But in the space involving the NOPD and the DA's office in terms of driving violent crime down in other areas, we've been delivering.
But you have to also recognize that since COVID across this country, because we had such a challenging time for our country, crime rates have come down somewhat after 2021, and that you have to recognize that this governor and this legislature has appropriated a substantial amount of funds and resources to a new Troop NOLA, and as also the Attorney General is getting involved. That has to have some weight on why you guys are having success. I don't think you can claim that success purely from your office.
Well, Senator Miguez, I think you had stepped out during the first part of
yes,
my
I was
presentation.
out for a moment.
I led with the high level of collaboration between myself and Jeff Landry and AG Murrow. I led with that. We began to have success in 2023 and 2024, but make no mistake about it, I am deeply appreciative to the governor and the AG reaching across the aisle to help find solutions to help us further drive crime. Look, there is success has many fathers. Failure is an orphan, and I am deeply appreciative to the Republicans that have leaned in to help the city of New Orleans, and deeply appreciative to the governor and the AG for everything they have done in the city of New Orleans. And so you missed that. I just want to make sure that is on the record, because I agree with you.
Yeah, I wanted to make sure you understood that it doesn't necessarily Republicans, but the legislature appropriated the money. You had an attorney general and a governor who are very aggressive, and they ran on a platform that they wanted to clean up crime. And most people across the state, including people from my area, which is New Iberia, not New Orleans, they have some substantial concerns at the time that we have a crime problem in New Orleans, and I'm not sure they feel safe traveling there now. They still have concerns, and it's incumbent upon you to do the best job that you can, so we can change that perception of the city, because it is a beautiful city, and everyone always enjoys the rich culture that we have there. But let me ask you, switch gears for a second. Emily Maw, I had asked Ms. Rodriguez if she had any information as to why she resigned. I know she was the center point of conversation in this last oversight hearing. Can you tell me why she resigned from your office after that hearing?
It was after the hearing. It was just time.
Did you ask her to resign?
It was just time for her to step on, and I'm not going to get into what she's doing now, but it was a mutual decision.
Mutual, meaning you had a conversation with her, and would you accept? Would you do you have issues with her job performance before she resigned? Did you have issues with her job performance or the way she was running her division before she resigned after the oversight hearing?
Her leaving the office was not a result of the oversight committee hearing.
You said it was mutual. You had some concerns with her job performance?
No, the only issues we ever had dealt with when she was playing out a position and working in magistrate court during that Mardi Gras issue when we were understaffed. I disagree with decisions there, but no.
Okay.
Yes, sir.
The 13 cases that got brought up, understanding, well, there were 16 that were mentioned, 13 are still out there. Jeopardy has not run on those. Do you foresee those cases being taken back up and continued? If you could have a communication line with law enforcement or establish contact with victims?
Yes, sir. Yes, sir. In fact, that is the way we operate in all of our cases. If we've got a case that we are trying to pursue, and whether it's because of an issue with a law enforcement witness or an issue with the victim or the survivor, if we can turn that around and get them on board, we go back at it, which is why the proper position should have been dismissing the case rather than moving forward.
And there was, Ms. Rodriguez mentioned something about you were in a similar position at our last oversight hearing about a case that hadn't been taken up since promises were made to this committee. Can you elaborate on why no action was taken?
It's an open matter. It would not be prudent.
But
let me
your
just,
position
things
remains.
don't always happen
Your position remains the same?
It does, but I just want to be really clear. Things don't always happen within a year or within 6 months or what have you, and there are other factors that we have to deal with and can only put forward the evidence that we have.
And I asked Ms. Rodriguez some very pointed questions, and you brought my testimony, our exchange up just a little bit earlier. And I asked her if she thought that you were intentionally doing this. For the record, she did not answer to the affirmative. She just mentioned that she had a tremendous amount of concern with the ADAs, and we just kind of got to the bottom that they were, I'm trying to use the most polite word, they made a mistake in their job. And it's still up in the air whether with your involvement, but you did mention that the buck stops at you, but she did not say that you were the one doing this, but she thought that we should look into it deeper.
Yeah, I mean, the job of a prosecutor is to prosecute, but to suggest that I want to lose, it's offensive. I don't even understand it.
Well, I appreciate you answering my questions and showing up today.
Thanks, Senator Ramirez. Senator Barrow.
Thank you, Mr. Chairman. Thank you, Mr. DA. Thank you for being here. You being here today really shows and tells me a lot about who you are and your character, and that you came here to answer any questions that were being asked, and I certainly do appreciate you for that. I would like to ask you, though, what has happened in your office? To me, I see like layers of things. I don't just see one blanket issue, but do you think this is happening across the state? Do you believe that some of these situations, decisions are being made perhaps across the state? I know that you can't speak to nobody else's vision, but do you, as it relates to, I heard you say something about the two ADAs in terms of what I heard, maybe experience or lack thereof, or new to the position. Are these some of the issues that we are facing across the state that may be happening, not just in New Orleans, but just everywhere? It
is feasible, and it is possible, because there is no way to know unless you watch every single trial, every single day, or get a transcript of every single case. And so in larger jurisdictions where there are thousands of cases, there is not a system that would give you that answer. And as long as there is not a law that stops the defense from, say, asking for a judge trial because they think the judge is going to be friendly to their client, if there's no way for a local prosecutor to get in the way of that and say, no, Judge, you already said how you felt at motion hearings. You found no probable cause. You said the police shouldn't have even arrested him. You've taken the ankle monitor off over our objection. We know what you're going to do here. 35 other states would never allow a judge to be able to do that. Now, let me say this. 11 other judges at Tulane and Broad, they would have stopped it themselves. They would have called me. They said something odd's happening here. But in this particular situation, it did happen. So, to your point, we don't know unless we ask the question about what the numbers are in other jurisdictions. So
judges have a lot of discretion.
Yes, ma'am.
And that's one of the things that we have allowed them to have. And that's one of the things they have asked to have. But the proposed legislation that you're talking about, would that take away some of that discretion?
I don't think it takes away their discretion. It just balances both sides of the V. Mm-hmm. Both sides have a right to a fair trial. Correct. Victims have rights. Police officers who come to court and sit and wait for their opportunity to testify have rights.
Right.
I mean, I just think about what it feels like to a police officer, and we don't have enough police officers in Orleans Parish. They're working double duty, right? And so when they're sitting in court, they know that their best use is to be out in community responding to calls for service. So when they do show up and they do testify, and a judge says, well, I don't believe you, that's got to be debilitating for those police officers. And I frankly understand why they might not want to come to court at a trial where the judge has already said what he's going to do, because their services might be better spent responding to calls for services, helping somebody in a crisis.
That's very interesting. Another thing that you stated was people don't want to testify, and so the cases that have been referenced here, they are all those cases like within a year, or are they longer?
These cases, I can't say with regards to all of them, but most of them were within a year or about a year.
Okay, so when you say that people don't want to testify, how do you know that? Is it because they don't show up, or is it because they have actually stated that they don't want to testify?
Yeah, so that's not coming from them just not being present in court. We have a system called PBK, Carpel, and so there is an entry every time throughout the life of a case when my ADAs or my victim witness or my investigators either go to the home, make a phone call, if it's an email, if it's a text, and the mode of communication is documented. What our team said is documented. What their response is documented. So in a number of these cases, you had individuals saying, I want there to be accountability, but I'm not coming to court. In another instance, someone said it was inconvenient because they were in school. In another situation, someone said that we were stupid and our case is stupid and they can't believe that this is still going on. Now, we're the state. And when it comes to domestic violence cases, just because a survivor has changed their mind, we can't let that go. And I've given my team, and perhaps I was too hard in this respect, but I've given my team a very clear message that even if a victim in a domestic violence case doesn't want to go forward, we still must do what we can to hold this offender accountable so that this battery doesn't turn into a homicide, because it oftentimes does. And, a lot of times bank accounts, sometimes bank accounts are shared, houses are shared, they have children together. It's a very tough situation. And frankly, sometimes some of these victims are still in love with their abuser, with the defendant. Sometimes they're paying the public defender. And so I'm not sure, one of the senators brought up the question about, well, how did the defense know there weren't going to be any witnesses? Well, sometimes the victim is communicating with the other side, this lawyer, because they want the batterer to get off. And it's a very tough situation. And so I can't let those cases go. And I really imparted on my team that we have to figure out any angle we can in these DV cases. Most of these 14 are DV cases.
That's interesting within itself. And so for the two ADAs that were seemingly assigned to the same cases, is it because supposedly they had like a specialized area, or this was their...
They were just the trial line ADAs that had been assigned to Leon Roche. They were very new, very young. We don't have enough experienced prosecutors for each of the 12 sections of court, and sometimes people are green. And when you're in front of a judge in a robe, you assume the judge is right.
Of the two DAs, one was a junior, one was a senior, right?
Well, technically a junior and a senior, but they were both new to the office and young lawyers, is what I'm saying. They're not old gray goats like me.
So clarify that for me, please. What do you say you mean a junior and a senior? What does that mean? Does that mean like years, or is that something else?
The senior ADA would have more experience than the junior
experience
ADA.
Based on what?
It would either be number of years or number of reps in court. Right, you could have a younger lawyer who's actually tried more cases, and that experience would make them a senior. But in both of these situations, they were new to the profession.
Okay. And so I think that kind of concludes my questions to you. This gentleman right here, I have not heard you say anything. Would you introduce yourself and tell me what is your role and responsibilities?
It should be on. You just got to get it closer to your mouth. There you go.
My name is Ned McGowan. I'm the first assistant at the DA's office.
So what is your role and responsibilities? I see you at the table, so evidently you have some kind of key position here. Or...
All the legal departments, including the trials division, report directly or indirectly to me.
So does that include the ADAs?
Yes, they would report to a chief of trials who reports directly to me.
So you have the responsibility of overseeing those, and then I would assume sharing anything that may be of concern maybe to the DA?
Absolutely.
So did you do that at any point?
Well, again, as soon as this issue was made aware, made aware to the office, we retrained the 2 ADAs involved, gave training specific to the entire trials division, and addressed the matter so that it wouldn't reoccur. As I think has been said multiple times, by looking at the minute entries and other readily available information, it wouldn't be knowable that this was going on. And I think it has been said several times, most of the other judges would reach out immediately, and they do reach out immediately for all manner of concern. And so as soon as we heard that this was happening, we immediately addressed it both individually with the ADAs involved and with the wider ADA trials corps.
So you are like their supervisor. Is that, can I kind of say that for lack of a better word?
Oh, that's exactly the word.
Okay. So as their supervisor, you didn't pick this up until it was made, I guess you were made aware of it. So because of the transcript, that's why you didn't know. I mean, as the person who's responsible for them, you would not know like what things to look for or things to be concerned about or things that you should have questioned?
Well, I think on the surface, as has been noted by the statistics and the initial news report, the fact that these not guilties were happening in those bench trials, that in and of itself was more of an indicator of, what was happening in those courts, not necessarily looking at the cases that there was some defective procedure happening in the trial itself.
So you guys have talked about what you have done to actually address the ADAs. What have you done to ensure that something like this doesn't happen again, where you just didn't know until someone brought it to your attention?
Well, again, I'm in court almost every day, personally. In fact, I'd be there today right now if I weren't here. We have multiple layers of supervision. We have open lines of communication with all the judges. I think most, if not all of them, have my cell phone and reach out on a regular basis. We have closing procedures in the office that we have fine-tuned and readdressed to make sure, if possible, that we could identify certain of these issues. And we do pay attention to the trial statistics and are vigilant to make sure something like this doesn't reoccur. And again, training constantly as we get new ADAs and retraining the ones who have been there on the specifics of the law and the expectations of the office.
And that sounds pretty good. I'm just trying to hear, what have you as the supervisor and maybe your team have instituted to ensure that you're looking, because this was something that you did not catch, nor did your team on the surface at the beginning. It wasn't until someone brought it to your attention. So what mechanisms or protocols have you placed or put in place, or you, Mr. D, have put in place to ensure that it doesn't happen again?
One of the things, when I said we had very tough conversations, was it was made clear to all lawyers in the office that they would be terminated immediately if this were to occur in any section of court again. And we explain all of the legal ramifications, ethical ramifications that exist with regards to their bar license. Because, just because you work at a place, every lawyer has their license and they should want to protect it. And so we trained on the ethics of it. We also trained on the problematic nature of it as it relates to cases. The other structural change is a new chief of trials and a new system that will, instead of having 2 deputy chiefs, we'll have 4 to 6 deputy chiefs, meaning more eyes on people in court all day than we've had before. Part of that is part of that issue is a financial constraint because we just didn't have enough resources to have that before. We've asked the city council to help us pay for more deputies if possible. The other piece of that is you can't find trained, experienced lawyers growing on trees, and so we have to grow that because we often lose our experienced ADAs to St. Tammany Parish, Colin, Jefferson Parish, and the U.S. Attorney's Office because they get so much, and the AG's office, because they get so much training, because no other place are people doing motion hearings day in and day out, trials day in and day out. So we lose a lot of our experienced people to agencies that can pay them better, and they can have a smaller workload.
Well, you had me going until you said funding. That whole funding piece is a whole nother conversation based upon what we saw today.
Yes, ma'am.
That I don't want to personally delve into a little bit more. But I do appreciate that you guys are leaning in a little bit more. And so going forward, do they have to come, before any decisions are made, do they come to you for permission? Will I'm sorry, what's your title again, sir?
First assistant.
First assistant. So will the first assistant have to get permission for you as they're actually addressing some of the cases? Do you have to sign off, or are you reviewing these? Or if you guys are seeing too many cases that look very similar like these, what are you doing to ensure, and what do they have to do now to ensure that this doesn't happen again?
And so
I heard you say a couple of things, but
there is no approval that
no
a lawyer
approval
could get for this. This is prohibited behavior that should not have occurred. And so the training is such that has made it clear that it's a terminable offense if this were to occur. Now, there's some other areas, like let's use whether it is if someone wanted to reduce the severity of the charge or to a lesser offense, they would have to get approval for those things if they wanted to do something along those lines. They can ask for that. They could never ask to move forward with a case without having witnesses called.
Okay. Well, thank you for that. And I just want to make a closing statement because I hate when the partisan issues come up in these meetings, because at the end of the day, I think we all want the same thing. I live in Baton Rouge, and of course, some of the issues that we have here in Baton Rouge. We now probably are second, or as it relates to certain things and certain crimes that are happening. And at the end of the day, the people that I represent want to make sure that they are safe. They want to be able to go home. They want to be able to enjoy, ensuring that their kids can go to school, enjoy the community, can go wherever they need to go and come back home safely and reside in their home. So at the end of the day, we all want the same thing, and ensuring how we get there, we want to make sure that it's done equitably and fairly. So that's my final comments. But thank you so much. And again, I appreciate y'all being here to answer the questions.
Thank you, Senator Barrow.
Thank you, Senator Barrow. Mr. McGowan, you said that you addressed this situation when you learned of it, correct? You didn't learn of it until Mr. Goyeneche called Mr. Williams, correct?
I believe when the letter was issued by the JA's office, we received that letter, and that's when we learned of it, yes.
So you didn't have any idea that your ADAs were losing cases?
So, again, in all of those cases, the judge who presided over the trial had, in fact, already either found no probable cause at a previous hearing or even gone so far as to suppress the evidence. And so the fact that at a trial conducted by that same judge that the verdict came back not guilty, that is not in and of itself surprising. And that is a dynamic that has been at Tulane and Broad for as long as I've been a prosecutor, which I started off there over 25 years ago. And that is not surprising. And so it's unfortunate, but that was not in and of itself a red flag.
The number of acquittals, you're saying that I don't know, I'm not an ADA, I'm not a DA, but I am a manager of attorneys, and every time a case gets lost in my office, I know about it, and I want to know why. So you didn't say, why did you lose this case? Do you agree with Mr. Williams that saying you're ready for trial and then not putting on any evidence is malpractice?
That is an incorrect process, correct?
And that would be malpractice.
Well, we don't have malpractice in the criminal realm, but that is an incorrect process.
Well, that would it would reflect a degree of incompetence, don't you think?
I think it reflected two ADAs that were put in an incredibly difficult situation that made a bad choice, correct?
So incompetence violates the disciplinary rules, does it not?
I don't believe the two ADAs were incompetent.
Same. Okay. Senator Miguez.
Thank you so much. Mr. McGowan, how often do y'all run outcomes and stats with y'all case management system for review?
Since it is really easy to run those reports with any administrator, I couldn't give you a definitive number. You can run reports any number of ways. So, it's a lot.
I mean, do y'all have a program a procedure where you review this on a common basis, quarterly, monthly, yearly?
I believe within the trials division, outcomes are directly, at that time they were being directly managed by the chief of trials. But again, for these particular 16 cases, in the context of, I think the stat was 355 cases over a period of time, those 16 cases where there had been previous negative rulings by the judge that ruled on the eventual verdict, those in and of themselves were not red flags.
So they didn't come up in any of your reviews?
These 16 did not. If they had, we would have stopped it immediately.
Do you think that you need to have a process, maybe review this more often with your case management system?
We certainly have looked at our processes and have instituted improvements where we found them. I think, as has been said by multiple of the witnesses that have come before us, that based on the files and based on the minute entries, it would have been incredibly difficult to discern what was actually happening in these particular instances. Again, 16, 13 out of the hundreds of trials on top of the thousands of pleas that we do every year. I mean, it's a very, very serious situation. It's also an incredibly small portion of the volume of work that we do at Tulane and Broad.
And I apologize to the chairman if this is redundant, but at what point in time did the district attorney's office find out about these 13 cases? Was it when the gentleman called, or was it when it was put online? When did you guys find out?
Again, the JA's office issued that letter, and I'm not sure how that letter, I don't know if it was directed or CC'd to us directly, or if the MCC sent it to us, but almost contemporaneously with the issuance of that letter, we obviously had notice of it because the letter was delivered to us.
Okay, thank you.
So thank you, Senator Miguez. So you mentioned, both of you all have mentioned multiple times about the volume of cases and the number of matters coming through your office. But your office, your parish has half the cases of parishes that are bigger.
I think you need to look at those stats again. Most, if not all, of those district attorneys' offices handle traffic matters, and we do not.
No. None of the traffic were included in those.
None of the traffic.
None of the traffic were in that.
Ms. Candace,
And you have 87
I didn't get a
ADAs.
preview like you did, apparently, but we should break down the felony and the misdemeanor.
They were all felonies. Those were all felonies.
The 9,000 new filings.
Yeah. Okay. Thank you both. The board is clear. Do you want to say anything else, Mr. Williams?
Only that I value your partnership as an important branch of government. If I offended anybody up here, I apologize. It was not my goal. I believe, based upon our last discussion, that there are people who are working for people to get better results in all parishes. I think New Orleans is important to the state, just like you said, Senator Cloud. And when things like this happen, it is much more frustrating for me as a citizen and as a father in New Orleans than it is for somebody outside of New Orleans. And I just hope that you all realize that regardless of what you've been told about me or what you think about me, that we share the same goals as Senator Barrow said, of making this community safer, of continuing to reduce crime, and partnering with anybody who will help us do it.
Well, I appreciate you coming. I like you personally. I do have some issues with your office, as you know, but we'll just continue to work through that and hopefully make the state better, and particularly New Orleans and the greater New Orleans area. But thank you both for coming.
And I want to make sure my invitation to you all still stands to come and visit us in Orleans Parish, and I'd love to walk you around Tulane and Broad to see how that place is operating.
Well, I'm familiar with CDC, but not Tulane and Broad, but you never know when I'll show up.